My lord, may I be, my lord, allowed, my lord, to grant leave, my lord, with regard to, my lord, three, my lord, civil revisional application.
Yes.
My lord, the applications were partially affirmed, my lord, before the learned, my lord, the deputy commissioner.
Yes.
My lord, the final signature is yet to be put.
Yes.
My lord, Mr. Chatterjee, my lord, who has, my lord, the deputy commissioner, my lord, oath commissioner, he is on leave, my lord. My lord, there is uncertainty, my lord, that when he will join. My lord, until and unless, my lord, this is the final signature is done, my lord, I will not be able to, my lord, file the
No,
application.
what is the urgency? You
Lord,
can wait till tomorrow.
My lord, there is an uncertainty.
Anyway, give the slip. Oh, it is not yet affirmed.
Yes, affirmed. It's partially affirmed, but the final signature is yet to be put by
Anyway,
the.
but what is the urgency? You can wait till
My lord,
tomorrow or till
My
Monday.
lord, the urgency is that, my lord, the petitioners, my lord, are the, my lord, the tenants.
Yes.
The landlord has, my lord, arbitrarily, my lord, disconnected the electricity connection. I have applied before the rent controller, SDO, my lord, the concerned authority.
So against which order you are challenging?
My lord, that the disconnection order, restoration of, my lord, my electricity connection. My lord, the learned SDO, my lord, allowed to, my lord, restore, my lord, the electricity connection. Civil revision, my lord.
No, against who? Which order you are
My
challenging?
lord, I am coming to that point. My lord, the learned SDO has allowed to restore my electricity connection, against which, my lord, the respondent, my lord, preferred an miscellaneous appeal before the additional district judge, who has stayed the order of restoration order. My lord, assailing that order, my lord, I have filed this revisional application.
Anyway, just mention tomorrow, okay?
My lord, leave may be granted, my lord, to affirm it by any deputy, my lord, commissioner, my lord, who is present. Because
you give the slip, I shall see in the afternoon.
Lordship.
On urgent matter, FMAP was filed in the month of February and yet to be listed. And in the meantime, execution order has been passed. So
execution proceedings have started.
Started. Order has been passed.
Order. Anyway, you file it. It will appear tomorrow. So why didn't you mention all these days or for the last 8 months?
Actually, not it was.
No, it is already filed.
Yeah, already filed.
So it will be listed tomorrow.
My lord, may I be permitted to mention a matter? My lord, this is for correction, my lord. In the last order, it was recorded as the senior division. However, the judgment was
Anyway,
passed.
tomorrow it will appear to be mentioned.
May I mention one hearing matter 6 for 2021. Paper book is ready.
Which case? Yes.
There is a estimated matters, my lord, for in hospital.
The compensation case? Yes.
May I be permitted to mention one correction matter, my lord? In this said judgment, my lord, in the ordering portion, it was not.
Anyway, keep the slip to be mentioned tomorrow.
Oh, grateful, my lord.
That's another only one caveat was filed in the 1612 and order has been passed first day year started. So matter may can be listed.
No. Caveat is filed. You are for the petitioner.
And for the revision is.
Okay. So you serve upon the caveator.
Yes.
Serve upon the caveator. It will appear on Monday.
Monday last.
Yes. Serve upon the caveator.
No, I am the caveat. Order has been passed behind my back. Caveat was filed in 1612.
So have you filed any application for recalling that order?
No.
No. Then you file an application for recalling that order and serve notice upon the petitioner. Yes, call the list.
Item number 6.
Item 6, my lord, I am for the affiliate, my lord. And my other side, my lord, you are another, my lord.
Yes, you are for the appellant. Yes, record an order on the prayer of Mr. Poddar, learned advocate for the appellant. The matter stands adjourned till the next circuit.
Item number 1.
Correction for cost taken. Order was passed in 15.
What is the correction?
Correction, the cost title, name of the insurance company wrongly recorded, instead of Reliance, another company is recorded, and respondent name also be corrected.
The respondent's appellant's name is?
Reliance General Insurance Company Limited,
Okay, and Shravani De.
Savoni Dena.
Yes, learned advocate for the appellant is present. The matter is put up for necessary correction in order dated 15/12/2025. Stop. In the cause title of the order, in the name of appellant, it is recorded United India Insurance Company Limited instead of Reliance General Insurance Company Limited. And in the name of the respondent, instead of Shravani De, it is wrongly recorded as Indu Malik. Stop. Let necessary rectification be made in the cause title of the order dated 15/12/2025. Stop. Other contents of the order remain unaltered. Yes, pass over.
Second line.
Is there any caveat? Have you obtained no caveat certificate?
No notice has been obtained by the.
No, question is caveat checking is to be done before a revisional application is to be filed.
That was, by stating the.
No, caveat checking is done, not merely. See,
At the time of filing, it was.
maybe, but no caveat certificate is required from the department. See, if you-
There are no payment notice issued by.
very well, but that has to be verified by the department. Anyway, I'm keeping it on Monday. Yes, record an order. Let necessary caveat checking be done and the matter be picked up on 22/12/2025.
Item number 7.
Yes.
Item 7.
So caveat checking is done.
Yes, sir. They had appeared on the last.
Who is appearing?
And the activity service also.
No, but the other side advocate is not here. What is the urgency?
No, because the amendment, cross examination is going.
When is the next date fixed? Who is appeared? The other side has appeared.
And appeared, served also the copy.
Let me see.
Affidavit of crime.
No, there wasn't any direction to serve copy.
No, affidavit was there.
Oh, right. So you intimate the other side. Okay, I'll take it up tomorrow.
Again.
Yes, item 10, you are appearing. Item 10, okay, not today.
Item 11.
I don't see time for the, and this is the transfer matter for transfer of the case from, district judge Bihar to, district judge Dinajpur. The matter was filed under section 25 of the Guardianship and Guardianship by the father. Before the district judge.
It is appearing for the first time.
Yes.
Yes, record an order. Learned advocate for the petitioner is present. This is an application under section 24 of the Code of Civil Procedure for transfer of the petition filed under Guardians and Wards Act being miscellaneous guardianship case number 19 of 2025 under section 25 of Guardians and Wards Act pending in the court of learned district judge. Stop. The petitioner in the instant application has prayed for transfer of the case from learned district judge at Kuch Bihar to the court of learned district judge at Uttar Dinajpur. Stop. Let notice be issued. Service be filed. Let the matter appear before the next circuit. Okay, as the matter is sub judice before this court, parties may seek adjournment before the learned trial court, which may be considered.
Lord, in 12, I'm for the petition.
Item 12.
Yes, my Lord.
Yes, caveat checking is done.
Yes, my Lord. To my knowledge, it is done.
No, is it there? No caveat certificate is issued?
My Lord, kindly produces the record. এখানে থাকবে বলা that.
দেখুন তো ইয়ে আছে কিনা caveat, no caveat certificate দিয়েছে কিনা?
Filing এর পেছনটা দেখুন, filing page এর।
না না, certificate by the department. Caveat checking হয়েছে কি? So caveat checking is to be done.
ওই
Oh,
yes,
আছে।
there is.
No, it is appearing for the first time.
Yes, my Lord.
Yes.
sir. Now, my Lord, the learned civil judge junior division, my Lord, assumed jurisdiction under order 21 rule 97 wrongfully, and my Lord, in a suit which was decreed for declaration and injunction, she resumed my Lord jurisdiction under order 21 rule 97 and my Lord proceeded to my Lord order police cell. Kindly takes up the my Lord impugned order. It follows my Lord after page 69. After page 69, my Lord, is the certified copy. The second page of the certified copy.
Page 69. Yes. Page 69.
Yes, sir. Page 69.
70.
Page 69, my Lord, is the last page of the petition. After that, my Lord, the certified copy. My Lord, the order, your Lordship will find in the second page of the certified copy.
Yes.
My Lord, the order does not record as to why the police help is required. It summarily, my Lord, proceeds to decide upon order 21 rule 97, which is, my Lord, actually meant for a suit which is decreed for recovery of possession. This suit, my Lord, was admittedly decreed under for declaration and injunction. Order 21 rule 97 has no applicability to such suit. That is
Let us
my
consider that.
primary bone of contention. My Lord, takes up, my Lord, order 21 rule 97 once. Rule 97, my Lord, sub-rule 1, where the holder of a decree for the possession of immovable property or the purchaser of any such property sold in execution of decree is resisted or obstructed by any person in obtaining possession of the property, he may make an application to the court complaining of such resistance and obstruction. So, my Lord, the first paragraph of this section itself deals with the issue. My Lord, the doubt will be further cleared if my Lord sees order 21 rule 99. 99, the heading is dispossession by decree holder or purchaser. Where any person other than the judgment debtor is dispossessed of immovable property by the holder of a decree for the possession of such property, or where such property has been sold in execution of the decree by the purchaser thereof, he may make an application to the court complaining of such disposition. So, my Lord, essentially, this order deals with disposition. The bailiff has to go, the bailiff has to see whether there is any resistance to such recovery of possession. The bailiff has to report back to the court, and then this adjudication has to be done under order 21 rule 98 to 101. This has to be, my lord, tried
Yes,
as a
record an order. Learned advocate for the petitioner is present. This application is directed against order dated 4/11/2025, passed by Learned Civil Judge Junior Division, Shiliguri, in miss case number 32 of 2014, passed in connection with CIS 15 of 2017. Stop. It is the contention of the petitioner that the decree passed by the Learned Trial Court is the decree of declaration and permanent injunction. Thus, the application under Order 21, Rule 97, read with Section 151 of the Code of Civil Procedure is not maintainable. Stop. Upon considering the order passed and the relevant provision of Order 21, Rule 97, read with Section 151 CPC, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week and affidavit of service be filed forthwith. Let this matter appear before the next circuit. Pending hearing of this application, there shall be stay of miss case number 32 of 2014 in connection with CIS 15 of 2017, pending before Learned Civil Judge Junior Division, Shiliguri, for a period of 4 weeks from date.
My lord, can it be 8 weeks?
Let it be 4 weeks, because next circuit, you can mention it.
Deep law, Your Worship.
Worship 13, I am on behalf of the petition. This is an contesting application.
Yes, you are for the opposite party, yes.
Worship,
Opposite party, one.
Yes.
the
Two opposite party, I am for the.
Worship, this application, the petition has filed this application against the impugned order dated 4th July of 2025, rejecting his application under Order 26, Rule 10A, seeking for the handwriting expert. Worship. Worship, now the gist of the
Oh, well, let
case
me
is
see the
that
order.
order, Worship, 4th July 2025.
Okay. Order 26.
I have gone through the order, my lord. Impugn order.
Yes.
May I,
Yes, sir, yes.
See, as far as the order stated, what I found that although on the basis of the sole signature, because it is the suit which has been filed by the plaintiff challenging the defendant that the suit subjected stall premises, which was in his name, was been fraudulently mutated by the defendant, and after which by stating that the NOC was been obtained by the defendant from the plaintiff, which was been directly denied by the plaintiff. And as the pro forma defendant, who is the Kuch Bihar municipality, is the party herein.
Yes.
So at the time of the pleadings, one application was been filed stating regarding the application of regarding handwriting expert in respect of that sole signature.
No, question is, you see.
Yes, I
What is
admit
the
that
case? What is your case?
my
Your case is the defendant is unlawfully
unlawfully
occupying the
occupying,
areas. The
occupying.
defendant's case is this, that they on the basis of some documents, the defendant.
Sole
is-
sole documents. One
Okay, okay,
affidavit.
sole documents.
Full
So-
documents, one affidavit.
Yes,
One
now the
affidavit
question is, was the document
is
is
need to be
relied upon by
examined.
the defendant?
Yes, and it is need to be examined by the, which is from the very beginning, which has been
No, what is
alleged
the?
by the, now,
No.
now the main problem is that, Your Honor, during the filing of the said application, it is the part of the latches of the Calcutta advocate. The original was not within their, of course, it was with the pro forma defendant, which is the Kuch Bihar municipality. And that documents, without that documents, I hopefully admit, without that documents, that examination cannot be made. And kindly, I want to seek an section under 11 rule 14.
Yes,
If
which
Your Honor,
section?
kindly order order 11. rule 14.
Order 9,
Order
order
11,
26.
11. Order 26
rule 10A.
10 is for the handwriting expert,
Yes.
Lordship. Kindly, if your Lordship peruse the order 11 rule 14.
Yes,
Lordship, get it? Production of documents. It
yes.
shall be the lawful for the court, Lordship, at any time during the pendency of the suit, to order the production by any party thereto upon oath of such documents in his possession or power. It was in possession of the Kuch Bihar municipality. Relating to any question in matter in question of such suit, and the court shall think right, and the court may deal with such documents when produced in such manner as shall appear. Lordship, that this section, Lordship, that was, yes.
Yes.
No, it has been filed. Yeah, I admit it. No. I admit that the application was in filed before production of the documents, but it was originally with the possession of the defendant, pro forma defendant, who is the party to the suit. The London court ought to seek the documents and speed for the inspection, because on the basis, yes. No. And now I have stated, the plaintiff itself has stated that it is not in his possession, Lordship. I have filed an application, the plaintiff has filed an application, he has an. And,
Yes,
and
this order confines only with order 26 rule 10A.
yes, order under 26 rule 10A. The learned court earlier bench, at the time of argument also, the learned court was seek what action has been taken. I have filed, it is in the record also, Lordship, can you say, filed an application seeking the implementation of order 14 rule, order 11 rule 14.
Anyway, what do you say?
This order, there is no infirmity in this order, madam.
The court has a power. Your Honor, Lordship, the court has a power. ठीक है.
He filed separate application for the direct trial court, direct application separately.
So for this application is concerned.
But this application for
So what is the ground of your challenge here?
What
is the ground of challenge?
No.
This-
My ground of challenge.
Yes.
It was the suit. No. Original. Yes. Why? Because it is on the position of the Kuch Bihar municipality. How could I? No. Municipality has filed written statement. Your Honor, kindly see written objection. Kindly see page number 33. It has been filed by the defendant, pro forma defendant, who allegedly state that yes, the mutation has been made and the original copy is lying with us.
He did it, but this was not taken into record. After the missing order, taken up this matter, thereafter he filed this application. Was it-
Yeah. No. This application, from the very beginning, it was the
No,
allegation that this and one criminal case has also been pending.
What
So
is
far,
your application and order say 26 rule?
Yes,
10A?
yes, Your Honor.
Which page?
Kindly.
Yes, 42.
Uh,
Okay, this is
what
the
is-
objection.
Objection. My
Yes,
application-
41, 39.
39. Can I see, I have also, the plaintiff has also maintained that the.
Yes, anything else?
My prayer is only.
Okay, I've seen your application.
Yes, sir.
Yes, Mr.
The
Poddar,
court has
anything
the
else?
power to decide you.
Anything?
For handwriting expert, in terms of what is our document, must be produced. He is unable to produce the
How come?
document, and he did not. Unable to produce the document, report writing part.
Yes, record. Learned advocates for the parties are present, are learned advocates. This application under Article 227 of the Constitution of India is directed against order dated 4/7/2025, passed by Learned Civil Judge Junior Division, Shodor, Kuch Bihar, in title suit number 3 of 2016. Stop. The learned trial judge, upon considering the order dated, considering the application of the petitioner plaintiff under Order 26, Rule 10A of the Code of Civil Procedure, was pleased to dismiss the same. Stop. The petitioner, being aggrieved by the order passed by the learned trial judge, has come with this and application. Upon perusal of the order passed by the learned trial court, it appears that the learned trial court disposed the application under Order 26, Rule 10A of the Code of Civil Procedure by observing as follows. Sit out the last paragraph. Right, page in order. Heard learned advocates for the petitioner and learned advocates for the opposite party. Peruse the opposite party number 1. Peruse the petition file and the materials on record. Stop. It is an admitted position that the documents on which the application was made for handwriting expert was not before the learned trial court. Stop. Which is thus, this court does not find any illegality, find any irregularity of the order passed by the learned trial judge. Stop. However, as the learned advocate for the petitioner submits that the relevant documents are on which the application for handwriting expert is sought for is lying with the Kuch Bihar municipality, who is defendant number?
A pro forma defendant.
Pro forma defendant in the state suit. Thus, the state municipality can be directed to produce the said document. Stop. Upon considering the submission of the learned advocate, this court is of the view that although the trial court has power under Order 11, Rule 14 of the Code of Civil Procedure to direct production by any party upon oath relevant documents, upon production by any party upon oath of such of the documents in his possession or power relating to any matter in question in such suit, as the court shall think right. But this power cannot be exercised without any formal application
What's the application?
being made by any of the parties giving the necessary particulars.
Application
Stop.
has been made.
It is submitted by the learned advocate for the petitioner plaintiff that a necessary application has already made in this regard. Thus, in the interest of justice, this court requests the learned trial court to consider and decide the said application in accordance with law and take a decision thereto. Stop. This application stands disposed. It is however made clear that this court has not gone into the merits of the suit and it is open to the merits of the suit. And all parties are kept open to be agitated by the parties.
The plaintiff can file further for this.
No, your submission is application on in this regard is already pending.
Already pending.
Very well, let that be decided in accordance with law. I have observed that. ওই যে অর্ডারের যেটা আছে ওনার ওটা কোট করে দিতে হবে। Yes, not today.
19,
Not today.
32,
Yes, same.
24,
Yes, not today. 26 also not today. Not today.
28,
Not today.
29,
Yes, same.
31,
Not today.
32.
Yes, not today. 32. Yes. No, question is it within the period of limitation?
Yes.
You are the appellant. So let service of notice be effected. देखिए recorded. So service is not complete. Yes, record an order. Learned advocate for the appellant is present. Let appellant is present. Let notice of this appeal be served upon the respondents. An affidavit of service be filed. Let this matter appear in the next circuit. Appear in the next available circuit.
Yes, Lordship, I am for the applicant, Lordship. In this case, Lordship, there is a reflection in the cause list that there is some defect, Lordship. But.
You are for the appellant insurance company.
Yes. Lordship. Case file, Lordship, I have already deposited the schedule for this one.
So where is your application for stay? Without application for stay, how stay can be passed? Anyway, statutory. Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 9th day of January 2025, passed by Learned District Judge Kuch Bihar in MSC case number 18 of 2019 for a period of 5 weeks. Stop. The appellant is directed to deposit the entire awarded sum along with interest as directed by the Learned Trial Court, excluding the statutory amount within this period of 5 weeks. Stop.
Lordship, at least 6 weeks, Lordship, because.
No, in all matters, I have made 5 weeks.
This
In the event, such deposit is made within period of 5 weeks, the ad interim order. Now, in the event such deposit is maintained within the 5 weeks, the petitioner will be at liberty to file an application for stay for further extension. You
Great.
deposit and you file an application for stay. Thereafter, it will be extended.
Yes, Lordship.
Liberty to mention.
Thirty-eight, Lordship, same Lordship, in this
Can
case
take it.
also, there is a reflection of defect, Lordship. I have deposited
38.
the statutory deposit on 10th September 2025.
Yes, record an order. Learned advocate for the appellant insurance company is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay, ad interim order of stay of the judgment and award dated 6 June 2025, passed by Learned Additional District Judge, First Track First Court, Alipurduar, in MACC number 11 of 2020 for a period of 5 weeks. Stop. The appellant is directed to deposit the entire awarded sum along with interest, excluding the statutory amount as directed by the Learned Trial Court within this 5 weeks. In the event such deposit is made within 5 weeks, petitioner, the appellant will be at liberty to file an application for stay for further extension of the interim order. Liberty to mention. Yes, next.
Lordship, in item number 39, Lordship, on the same 39th, on the same judgment, 2 appeals have been filed, Lordship. Yesterday it was running in the list, so on the prayer of the appellant, Lordship, both the matters have been analogously listed
So
today.
let this,
So,
the other appeal appear.
Yes, she's there, Lordship. 2 appeals are there and 2 appeals.
Yes, let this matter, let this appeal appear along with FMAT
No,
number.
this direction was passed by yesterday, Lordship. So according kindly see the last order, Lordship.
When it is due to appear.
Already appeared, Lordship.
No, matter is listed.
Yes, listed today. Yesterday it was running in the list.
No, one matter is not appearing in the list, okay?
Yes.
So let it appear, kalke list করে দেবেন.
There's a direction, Lordship.
Yes, tomorrow it will be listed.
Lordship. Yes, by God's permission. Grateful, Lordship.
Yes, whenever you deposit the statutory amount, always file an application for stay. Otherwise, only just a limited stay will be granted. If you want an absolute stay, deposit the entire awarded sum and file an application for stay. Otherwise, no, it cannot be granted. Dekhi recordটা.
This also I have not filed the.
Yes, give that slip, that statutory deposit slip. What is that slip?
In this case, there is no reflection of defects, Lordship. I have already
Okay.
deposited the.
So, have you, no statutory amount has yet been deposited. This is the
reflection.
report of 24/11/2025. Anyway, I am making it not today.
Yes, Lordship, I will.
You take instructions,
Alright.
bring that slip.
Lordship.
Yes.
On behalf of the applicant, statutory deposit has it done?
So this is also the same. We have not filed any application.
Just.
So it will be only for a limited period. So
11.
from henceforth you file,
No,
okay.
It
And
was just
extra-
filed on 11.
and suggest the insurance company lawyers, because in Calcutta, this mistake is not made. Everybody is filing application for stay.
Along with
Yes,
the-
if it is deposit is there, limited.
No.
After the entire
Okay.
deposit, absolute.
No,
And here I find 90%, no
She just-
application.
only filed on 11.
Yes, record an order. Learned advocate for the appellant is present, as the appellant insurance company has deposited the, you filed that challan?
Yes, yes.
Filed the deposit, statutory deposit of rupees 25,000. There shall be an ad interim order of stay of the judgment and award passed by learned additional district judge, first track, first court, Alipurduar, in MSC case number 7 of 2019 for a period of 5 weeks. Stop. The appellant insurance company is directed to deposit the entire awarded sum along with interest from the date of filing till date of deposit as directed by the learned trial court, excluding the statutory amount within this period of 5 weeks. Stop. In the event the entire deposit is made within this period of 5 weeks, the appellant will be at liberty to file an application for stay for further extension of the interim order. Liberty to mention.
Great.
Suppose you see, when an application for stay is there, the order will be, the ad interim order of stay will continue till disposal of the application. When an application is there, but in the absence of application, only liberty.
We'll take-
Yes, not today,
44,
not today,
45,
not today,
50,
not today.
47,
Same,
48,
yes, same,
49,
same order.
51.
52.
51, not today.
52,
Lordship, actually, almost same submission, Lordship, on the same judgment, Lordship, two appeals have been filed, Lordship. So one is actually has been fixed tomorrow, Lordship.
Okay, let this matter appear. Let this matter appear on 19/12/2025, along with FMAT MV number.
Number, Lordship, I'm giving the number, just I'm searching it out, just give me.
Give them the number.
I'm giving number, 71/25,
FMAT 71 of 2025. FMAT MV
MV.
71 of 2025.
Lordship. Grateful, Lordship.
Yes. Yes, can one? No, can one is for what? Stay. And can two? Can two? Condonation of delay. দিন তো রেকর্ডটা একটু। Can one টা কি আছে? Oh, can one is a limitation act, section 5. Have you served can one upon the opposite respondents? To serve and come. Learned advocate. Anyway, you see entire The question is section 5 upon, you see, allowing this condonation of delay, thereafter your stay and everything will be taken up. First section 5, then admission, then that other. Learned advocate for the appellant is present. The application under section 5 of the Limitation Act is taken up for consideration. Stop. Let copy of this application be served upon the respondents within 1 week and affidavit of service be filed forthwith. Let this matter appear before the next circuit. As the matter is sub judice before this court, parties are at liberty to seek adjournment before the learned trial court, which may be considered. Same, section 5 not served. Okay, same order. Fif- 56. Okay. 58. You are for? Clement. Who is appearing for the respondent? 58. Okay, you are for the appellant insurance company. If you have a copy, you give your learned friend. Okay. How many days delay? देखिए रेकॉर्डটা দেখি। Yes, what is the defect here? No, statutory deposit. You have not filed the statutory deposit.
There is no delay. In fact, it's valid for the fiscal particular bank account. Already 5%, 25 already.
Yes, deposit is made. Deposit is made, there is no defect. But why it is given as, this is item number 80, 60.
88.
58. So there is no delay. Yes, record an order. Learned advocate for the appellant and learned advocate for respondents number 1. Respondent number 1, Clement, are present as learned as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be an ad interim order of stay of the judgment and award dated 29th day of April 2025, passed by the learned additional district judge, Second Court, Alipurduar, in MSC case number 1 of 2024 for a period of 5 weeks. Stop. The appellant insurance company is directed to deposit the entire awarded sum along with interest from the date of filing till date of deposit as directed by the learned trial court within this period of 5 weeks. In the event the entire deposit of the awarded sum is made within the period of 5 weeks, the petitioner, the appellant will be at liberty to file an application for stay for extension of the interim order. Liberty to mention. So file an application for stay and get an extension till disposal. Copy, yes. As learned advocate, as the respondent number one, claimant is already represented, service of notice is dispensed with regard to respondent number one. Copy be served upon the learned advocate. Can file হয়নি। Can is there? No, in this particular case, it is not appearing in the list. Huh? না কোনটা এই যেটা কল হলো না যেটা আগেরটা দেখি জাস্ট অর্ডারটা কেন আছে তাহলে ওখানে একটু কেটে দিই ইন দ্য ইভেন্ট দি এন্টায়ার ডিপোজিট ইজ মেড উইদিন দ্য পিরিয়ড অফ ওই যেটা আছে যেরকম হ্যাঁ 5 weeks the application for the ad interim order of stay shall continue till disposal of this application. Can want to disposal on a next date. Item 60. So, sub copy of the section 5 application. Yes, record and order. Learned advocate for the appellant is present. The application under section 5 for condonation of delay is taken up for consideration. Stop. Let copy of this application be served upon the respondents within 1 week and affidavit of service be filed. Let this matter appear in the next circuit. Okay, then 62.
And for the respondent number 6, owner.
Item 60.
1.
62 and 3 you are not appearing. আচ্ছা 61 এ অর্ডারটা একটু করে দিন learned advocate for the appellant and learned advocate for respondent number 6 vehicle owner are present. The application for section under section 5 of the Limitation Act is taken up for consideration. As service of notice is not effected upon respondent number 1 to 5, let notice and copy of the application under section 5 of the Limitation Act be served upon respondent number 1 to 5 within 1 week and affidavit of service be filed forthwith. As learned advocate has appeared on behalf of respondent number 6, service of notice upon respondent number 6 is dispensed with. Let this matter appear in the next circuit. Sixty-two also. আচ্ছা 62 এর আগের অর্ডারটা যেটা আছে সেটা করে দেবেন। That is probably 60 item 60 যে অর্ডারটা হয়েছে ওটা করে দেবেন 62 তে। আচ্ছা তাহলে সেম অর্ডার as 62 okay 63 64 also same order okay 65 except 61 the vehicle owner has appeared.
Out of time and I've already filed the application for conversion of
Will
delay.
you serve
So
copy?
let the direction to serve the copy upon the.
আচ্ছা এটা ওই 65 এর মতো করে দেবেন ঠিক আছে 65 এর যেটা লাস্ট অর্ডার হল এক অর্ডার করুন
Grateful, Lordship.
Seven.
67 not today
68.
yes same
69.
yes same
71.
same
74.
yes same order
75.
yes same order
76.
76, my lords, there is a defect, my lords.
so cat 1 is your application
Yes, my lords. That
you are
is
for the
delayed.
appellant
I am for the appellant. My lords,
so have you served copy of this section this is what
yes, my lords,
application
I have served copies.
let me see
My lords, that's from the affidavit of service, my lords, it has not been yet delivered, my lords. But my lords, regarding the defect, my lords,
yes
there is
what
a defect in this, my lords, appeal, my lords. The defect is that, my lords, the decree, my lords, of the, my lords, trial court is not there, my lords. And my lords, but the fact is, my lords, we had already, my lords, submitted the decree, my lords. I also have a receipt.
so I'm
copy.
granting you I am granting you liberty to rectify let it appear next
My lords,
week
we had filed the decree, my lords. That is a, my lords, defect.
where have you filed the decree of the trial court
Yes, my lords, we have filed, my lords, but it's not traceable
Yes.
from the department, my lords. I have
Has
the
been
receipt
filed.
copy.
okay wait you are the plaintiff appellant in this suit
No, my lords, I am the defendant.
defendant
Yes,
appellant so you go through the report okay I'm keeping it on Monday
my lords.
record an order learned advocate for the appellant is present learned advocate is requested to produce the report of the stamp reporter and take necessary steps let this matter appear on I'm keeping it on Tuesday
That's Monday, my lords.
okay
Not the
22/12/2025 in the meantime you obtain a track report whether the service is complete or not
Order, my lords.
Nine. 80.
Lordship, in item number 79, I request the matter to be placed on next circuit kindly.
yes record an order on the prayer of the learned advocate for the appellant the matter stands adjourned in the next circuit
I'm grateful. Lordship, it's only 79.
79 and 80 analogous
একসাথে আছে আচ্ছা আমার উপর সার্ভিস Lordship, then 80 was not served even on me.
mention before the court or you write to the learned advocate
No, additionally, if a single line can
no
be,
question is 80 let it appear you can intimate that you are appearing to the learned advocate definitely he has to serve you
no, he has not yet.
he has to
81.
That's- হ্যাঁ
81 yes who is appearing
I am for the.
yes you are for the opposite party insurance company Yes, what is the ground of challenge?
My lord, the learned tribunal field have considered my annual income, my lord.
Yes.
Annual income, actually annual income is, my lord, page number 44.
No.
Last year as
What was the occupation of the victim?
businessman.
So did you furnish the income tax certificate?
Yes, my lord.
Income tax return?
Yes, my lord. 44, page number 44, my lord.
Yes.
Annual income, my lord, 2,64,160. Does not consider an income 11th income as insurance 11,000.
That was for which year? The last, before his death?
Before his death, madam. 15, 16.
That is 3,41,560.
Gross
So-
income, madam,
So total
3,41,000.
income is, 3,41,560.
561, 41,000. Oh.
And what was the income assessed? Considered by the learned trial judge?
11,000, my lord. 11,000
11,000 per month.
per month.
Was the income tax authority examined?
No, man.
It was exhibited.
It
This-
was exhibited.
Page?
90.
What was the occupation? Business. What is the nature of business?
No, it's not mention the nature of business, my lord.
Yes.
Main problem there is tribunal did not consider the income tax return. Because they have filed a Xerox copy or photocopy of the income tax. And I am just referring the judge according to judgment, the Xerox copy is not there. First of all, proof by the IT department, or secondly, certified copy, or at least a receipt original copy, not the photocopy. As per evidence, it has no value.
So can you file the original copy? The matter can be taken up for consideration.
And assess the income as real income.
No, was this Xerox copy exhibited? Anyway, if it is exhibited, what remains? Yeah. Yes,
he agrees.
yes,
Then income will be 1,000 then.
yes.
But the
Income,
monthly,
I think that,
no, monthly 11.
but it's going over of the
if it is 50,000,
15,000.
15,000.
7,000. If the local government not here, otherwise this, I think. Better than local.
No, question is. Now the question is, so if you are agreeable, then that order can be passed.
Take just 11,000.
No, what is the nature of his income? That is the thing.
Mentioned
You
there.
know,
So let me remit the matter back to the tribunal, granting you liberty to exhibit these documents.
it is difficult to 15, 16.
Yes,
Now it is difficult to in the matter in the. To the
question is,
tribunal.
no, what was in your evidence, what have you stated regarding the income? Your occupation and everything.
Okay, it's better. Department and every possibility, they will call the income tax department and prove it and then.
Or else I can grant you opportunity to obtain a certified copy from the income tax department and keep it in the next circuit.
My lord,
Okay, as per the deposition of the wife, this Somendranath Saha earned rupees 30,000 per month. Return. No, income tax return has to be taken, you see, as a sacrosanct. I have passed a judgment, I will not go beyond that. But whether that Xerox copy, whether that has to be taken or not.
So the title is also encouraging cash.
No, consider the court after taking income tax return, you see, taking into account income tax return.
Yeah.
So the court has accepted the return. So after accepting the income tax return, what is the scope to fix it at 11,000? The court has to say that this cannot be taken into consideration, or it has to be taken into consideration. It was not the argument of the insurance company that the income tax authority was not examined.
But right now that is not accepting anything. It's after objection.
No, arguments. Arguments.
So that they-
Argument, it is stated income tax, insurance said that it is not reliable, only in income tax return. Anyway, I'll record your objection. But I can't record your consent that you are ready and willing. I either have to accept or modify or reject his case. Yes, record an order. Learned advocates for the parties are present, heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 22/12/2025.
Another thing, Lordship,
Yes.
just
number
for-
24.
then, the delay in filing, the period that is due, that the period of delay for filing appeal. In this case, the interest was not, it is 25.
Delay in filing this appeal. So
File.
this appeal. So interest, if it is to be given at best it is to be given from the date of filing of the claim case till the date of the judgment on the award. Yes, yes, this appeal delay cannot be taken. Only for date of filing of the claim case, till disposal of the trial court. Trial court, at best. Yes, রেখে দিন এটা।
Well, there is a can one already disposed of. But
Can
it
one
was-
for?
Condition of delay, my lord. It was already disposed of, like, but in first title it was mentioned first can one.
No, no, order sheet এ দেখুন তো can one টা disposed আছে? Disposed of, okay.
It's-
My lord, the copy has been served. Copy.
You are for the petitioner,
Appeal.
appellate, yes. Copy has been served.
Sir.
Can one?
Yes.
Can one is for? Condonation of delay? Let me see. Yes, what is the affidavit of service?
I have been instructed by the.
No, if you want the matter to be taken up and heard, you have to file the affidavit of service. Tomorrow or Monday? Okay, not today.
Waiting for 1 day accommodation.
Which
Yes.
case?
Okay, next case.
Yes. Yes, call 83. Okay, not today. Yes, not today.
89.
Not today. Yes. Yes. Can two is whose application? Okay, not today. Come tomorrow.
That, it is 5 months.
Can two, this is application for stay. Let it be heard tomorrow, okay? Tomorrow, if it does not appear, I shall pass necessary orders.
Lordship, I am on behalf of the applicant. So I've actually, Lordship, I've come before the Lordship. And my argument will be restricted to only 2 or 3 4 grounds, Lordship. So I'm challenging the order of the monthly income of the deceased, which has been assessed as rupees 3,000 per month instead of 9,000, Lordship. No future prospect has been granted. Number 3, general damage only awarded 4,500. Lordship,
Now, let me, what was the income? 9,000.
9,000, Lordship. Occupation, actually, he was a mason, Lordship. And so per the guidelines of the West Bengal government, Lordship, in the year, the accident occurred in the year 2014, Lordship.
So do you have that
Yes,
circular
Lordship,
regarding the minimum wages?
Lordship, I have.
Please.
Lordship.
Anyway, whatever it is, let me see that circular?
Lordship, this is circular, this showing the soft copy. I'm just bringing the hard copy. I've asked my junior to get this Xerox copy, Lordship. It comes with the definition of skilled labor, Lordship.
No, mason, nature, employer's name was given.
Masons actually, he's the only. he
No,
was
no,
associated-
question is, mason, maybe.
Mason actually, he's
But-
not one restricted to any particular employer, Lordship. Today he's working in this side, tomorrow he will be working that side. So it is not confined to.
So
any
in
particular-
which year the incident took place?
2014, Lordship. 14.
And 3,000 is taken into consideration.
Translation.
That is prior to Pranay Shetty.
Prior to, yes, absolutely, Lordship. Yes, Pranay Shetty. But in Pranay Shetty journal, Lordship, future aspect has, retrospective effect has been given, Lordship. That actually the case,
Question, how many regarding income?
Lordship.
So did you examine any third party?
No, Mason actually, so in case of Mason, it is very difficult, Lordship. Because actually he was not confined to any particular employer, Lordship. Only he was
Mason
associated.
means daily rated labor.
Daily rated level, Lordship. So that was the income chart actually as per the West Bengal government, Lordship. So I would like to refer one judgment of the Honorable Appeals Court, Lordship, in this regard, Lordship. This judgment was delivered in the month of May 13 to 2025, Lordship.
Is let us see, PW 1, 2, and 3.
Lordship. Page number 13 to 17, PW1, Lordship.
PW 1 is the wife of the victim.
Lordship. PW2's Lordship, Dhiren Baraik, 18 to 20, Lordship.
This is the eyewitness.
PW3.
Oh, right. Victim.
One third person has been examined, Lordship, in this regard. I'm sorry, Lordship. And that person was actually working along with that deceased. In these type of cases, Lordship, what happens actually, there is someone who is actually leader of this mentioned, Lordship. It had been locked, Lordship. And it's reopening, Lordship.
No, when is this circular issue? What you are relying upon? This is
Lordship,
an
in the year
incident of
2000.
2014.
Lordship.
Okay, when is the date of this circular?
Lordship. 2/7/2014.
27?
2014.
An incident took place? You
2014.
give a hard copy of that, okay?
I've got this.
Yes, what do you say? Yes. No, regarding what? This Mason?
No.
They, no income certificate, yes, because if a person works under a particular employer, there can be income certificate, but in these cases, these Masons, you see daily rated workers, laborers, usually
It depends, no, it depends. Supreme Court
but
recently.
if
Supreme
it is
Court-
believed from the depositions that he was a Mason, okay. Depends upon the nature of the occupation,
Lordship, for a moment,
not all occupation.
Lordship, for a moment, come to page number 26, Lordship. 21, Lordship, page number 21.
Yes,
PW3, Lordship.
yes.
Let me complete. He has been examined.
Actually, they can say that whether he worked as a mason, these persons cannot say how much he earned. That is not
the
possible.
thing. And so that is why in support of my contention, I'm filing this, bringing of circular of this West Bengal Government, Lordship.
So it depends upon whether a particular person is a full-time or part-time mason. It's a temporary work because it depends from the employment to
He has been
employment.
working for-
Today this person is working here, tomorrow under some other
Lordship,
person.
Absolutely, Lordship. But the minimum wages should be applied, Lordship.
Yes, minimum wages
It
act.
should be
How much,
applied.
how much it is there? 6,000.
No, Lordship, this is the hard copy, Lordship. It's skill level, no? 7,720.
No, mason is a skilled labor.
Skill labor, it comes with the definition, it has been defined here.
Okay, let's see. Unskilled workers.
Lordship, come, straight away,
So
Lordship, come to page number 2.
this is dated was July 2014.
Lordship.
Okay, and yes, building and roads, okay. Was July to,
Lordship, come to page number 2, Lordship.
when is the date of accident?
2 days before. At least 2 days,
28th.
2 days before, Lordship. So Lordship, kindly come to page number 2, Lordship, of circular. Skilled workers, Lordship. There is a sub-headings, skilled workers. Line 13. 14, for number. Skilled workers. Status. Fifteen.
No, here you see, it is not mentioned with regard to building or road.
The masons normally,
No,
actually.
this is with regard to particular, this mechanical works, okay? This is mechanical works, not this road construction or building construction.
No, actually, Lordship, at the top of the circular, Lordship.
Unskilled
Follow-
workers, so at best it can come under unskilled workers, and it should be zone B probably.
Zone B, perhaps, B. 6,381, Lordship.
At best, it can come to zone B.
Lordship, just I am referring the latest judgment of the Honorable Supreme Court, Honorable Justice K. Chandran, Lordship, along with Sir Lordship Sudhanshu Dhulia, Lordship. And this judgment has been pronounced on 13 May 2025, Lordship, this year only. So where, Lordship, it kindly. Paragraph number, Lordship, straightway come to paragraph number 5, Lordship. So
Yes.
this is the root judgment, Lordship. Ramchandrappa versus manager Royal Sundaram Alliance Insurance Company Limited determined an income of rupees 4,500 per month in the year 2014 to 2004 for a coolie, Lordship. So why I'm citing this judgment? Because it is a coolie, sir. He is also a delegated labor, Lordship. So a constitution bench in National Insurance Company Limited versus Pranay Shetty and others found that there would be an incremental increase in the income, which according to us would be reasonable if fixed at rupees 500 per month for every successive year. So in the present case, the accident occurred in the year 2015. So 11 years after 2004, and going by the principle stated in the apostate cited decision, the appellant, an unskilled worker, would be entitled to claim monthly income of rupees 10,000. In the present case, the claimant has asserted an income of rupees 9,000, which can be safely as adopted. This is the latest judgment of the Honorable Supreme Court, Lordship. So much controversy is going on, particularly on this point, notional income, Lordship.
Okay, you see, depends upon the
Circumstances,
where
Lordship.
there are minimum
Lordship,
wages.
absolutely, absolutely.
Even if see there is no bar to grant more than minimum wages.
Lordship, absolutely.
If market rate is prevailing.
Absolutely, going by the present state of economy and
Yes,
all.
market
Lord-
rate and
Absolutely.
you see the other factors.
So I'm just supporting
But
my
minimum wages is a guideline that you
Lordship,
cannot go
Lordship,
below,
Lordship.
although it is just prior to this thing.
Lordship, Lordship.
Yes,
As the
okay.
Lordship, another point is future prospect has not been granted. When multiply wrongly applied, Lordship, it should be 16 instead of 17. I'm fairly submitting, Lordship. One step ahead, actually 17 has been applied, Lordship.
Future prospect, what is the age of this person?
34, Lordship. So it should be 17. It should be 16.
So future prospect?
Future prospect would be.
Oh, it's a temporary, this mason.
Yes, Lordship. So it's not a permanent, Lordship.
So minimum future prospect.
Minimum prospect.
Yes, record an order. Learned advocates for the parties are present, heard learned advocates. Hearing is concluded. Let it appear for judgment on 22/12/2025.
Only available. My junior will be there, Lordship. So all the points are there. So let me, sir. Jail damage, only jail damage point, only 4,500 has been awarded, Lordship.
Yes, which case?
In this case,
Anyway,
4,000.
you have taken it in your grounds.
Yes, Lordship. So it should be 70,000. And multiply should be, no future prospect has been granted. All these are main points, sir, Lordship. Grateful, Lordship. 22.
Take it, chutney.
Lordship. So what happened, Lordship, in this case?
Yes, I told you to clarify the matter.
Lordship.
It is very difficult to believe that a private tutor will get 9,000 per month.
Lordship.
It cannot be the intention of the legislature or the executive that to fix the.
No,
it definitely has to be some tutorials or coaching centers.
Absolutely, Lordship.
It cannot be that one person going to the house of another to teach a person and he has to.
Lordship, it is very surprising that even for past student, even a kid, a child is studying class 1, the tutor is charging like 5,000 for past student.
Actually, you see, if that is the intention of the executive authority, no poor persons will be able to engage the teacher. So that is not the intention.
There cannot be any straight-jacket formula, Lordship.
So definitely that is there for some tutorial or some this
It is
coaching
not-
classes,
it
because you see there are tutorial homes which is earning a lot, engaging these
absolutely.
teachers,
It's like
engaging
2 lakhs, 3
teachers
lakhs, 4 lakhs.
on meager income. So that is why
Lordship.
these things are introduced.
Lordship. So I am just on this point, Lordship. What
You give, how do you ascertain this continuation? I gave you that document.
Lordship.
You give the continuing page also.
Absolutely, Lordship. Absolutely, Lordship. Lordship, allow me 2 minutes, Lordship. So just I'm arguing on this point, Lordship. So the judgment which was pronounced by the Honorable Supreme Court in the month of September 8th, on deciding of our Honorable Justice Sanjay Karol, Lordship, and along with side Prashant Kumar Mishra, Lordship. So motive of the judgment, even a child, nowadays, even a child cannot be treated as a non-earning person, Lordship.
Oh, for child, the criteria is different. Okay.
Different, Lordship. In the
He's the
same,
minor child,
Lordship,
but
in the
he's the
same,
major person, and it
in
is
the
the,
same judgment,
it
Lordship.
is the case of the claimant that he was earning.
Lordship.
Yes.
In the same judgment, Lordship, in the same breath, this has been asserted in the judgment, Lordship, that even a person, like in this case in hand, Lordship, it is the age of the deceased was 20 years old, Lordship. So in accident occur, Lordship, it is very important, Lordship. Nowadays, Honorable Court, actually one thing is very much giving importance when the accident occurred. So going by the present state of economy, Lordship,
No,
and
if accident occurred prior to pronouncing judgment,
it doesn't matter, Lordship, because pronunciatory judgment dealt with the case which accident prior to that. In the year 2011, pronunciatory dealt with the case which case accident occurred long back, 2011. So thing is that, Lordship, here in this case, we are only restricted to the notional income of the deceased, Lordship. What should be the notional income of the deceased? And no interest has been granted, Lordship. So here in this case, 6,000 has been awarded, Lordship, in place of 9,000. My submission was that accident occurred in the year 2022, and it should be minimum 9,000 at least per day, 300 rupees. So that was my contention, Lordship. In support of my case, Lordship, I have relied upon the judgment of the Honorable Supreme Court. So that is one of the judgments, Lordship. Another judgment is Sheikh Sadiq judgment, and in one pronunciatory judgment, one thing has been time and again has been echoed, that is, there should be an incremental increase in the income of the deceased. So that point is very much clear. So
no, this case also is after pronunciation.
after pronunciation, in the year 2022,
Is
Lordship.
incremental means what? With regard to those consortium?
No,
and
Lordship.
general
Income,
damages.
income.
Very well.
Consortium is different, Lordship. In the income of the
Because sometimes you see, when in case of minimum wages are there, very well.
Very
Courts can follow that minimum wages.
Lordship.
Unless
Lordship.
there are evidence to the contrary.
Lordship. In this case, Lordship, it comes within the, I have already showed.
Anyway, you have argued with regard to the monthly income, private tuition. You just hand me over that circular, which you relied on yesterday. I told you to seek clarification about the continuing page. Whatever you have, please submit that. You can show to your learned friend also.
Lordship.
You can show that to your learned friend also.
I'll show it, Lordship. So the minimum wage for a private tuition teacher in West Bengal 22, accident occurred in 22, varied depending on whether they were covered under the specific scheduled employment categories and their skill level. There was no single minimum wage specifically for private tuition, right? General, shops and establishments or similar categories. So it is similar to.
That means you see those who are engaged in these tutorials and all, these are also some establishment.
Right, Lordship.
Coaching center and tutorial. If you have a coaching center and you engage Mr. X to do some full-time work or whatever it is.
But what we find here from the cross-examination and examination of the mother of the deceased, it has been categorically time and again said that the deceased was their past Madhyamik examination.
That means you see, when a young boy or girl goes to the residence of somebody, and for coaching, that is one thing. If few of the friends run a center, or that is another thing.
Absolutely, Lordship.
But when a specialist or a professor or something
automatically
is running a tutorial home, okay, and earning a lot of income by appointing a teacher with a meager income,
Lordship,
for them this protection is there.
Absolutely, Lordship.
Not for this individual persons going from house to house for the purpose of.
Absolutely, Lordship. Your Lordship,
So
actually,
anyway, whatever is the deposition that we have to consider.
Lordship,
Yes.
Lordship. Considering on that
And whatever you had that circular, you give that?
so I'm not getting the second one, Lordship.
Yes, I have to deal with that. Yes, what do you say?
I will see the data on the page for, my lord.
Page
It
40.
is my-
This
It was the labor, and they were going to work at big factor. When accident took place. That is,
This is by the same person who is PW1.
PW, the FIR,
No, the FIR lodged by whom? PW1.
No.
Rezaul.
No.
Rezaul means what? Local person.
Rezaul means.
Third person.
No, আমার ভাইতো
No.
কাকাতো গ্রাম যে আঙ্কল অফ চিঠি আঙ্কল অফ চিঠি
So there are some contradictions about the occupation of the victim.
Where is contradiction? কি বলতে চাইবো?
10টা নাগাদ আমার কাকাতো ভাই মনিরুল আমি পিতা ও এত করতে আমিনুল আলী এত নাটাবাড়ি সাহেবগঞ্জ প্রক্রিয়া তার বাড়ির সামনে থেকে রওনা হই 1 তারিখে ইনভার্টারে কাজ করে
হ্যাঁ, তো কি কাজ করার জন্য? কমপ্লেনেন্ট। Complainant, the complaint is the FIR maker. Complaint is the FIR maker. And who is the deceased? Who is the deceased? See?
So that is a contradiction.
Lordship, what he is stating, Lordship, that he was working in a Eid Bhata, big factory. But this is not the case, Lordship. কোচবিহার তার বাড়ির সামনে থেকে এত নম্বর বাসে করে ইট ভাটার কাছে পূর্ণিয়া রওনা দেয়, কত মধ্যেই ঘটনাটা ঘটে। কোথায় বলা আছে he was working, কোথায় বলা আছে he was working in a big factory? Show me. আরে ও তো যাচ্ছিল পূর্ণিয়া, যাচ্ছিল। হ্যাঁ, কি বলছে? না কি বলছে? এখানে কি বলা আছে ইট ভাটা কাজ করছে? কি বলতে কথা বলছে?
No, is there any specific deposition that he was going for his work?
No such deposition.
Just that this person, FIR maker, is the labor. Yes, cousin brother.
সেটা কোনো সন্দেহ নেই।
So far, this person who is the FIR maker, he is the laborer.
He is the labor.
But what is the occupation mentioned in this?
Private.
No, yes? No, in the FIR, what is the occupation mentioned?
No occupation I mentioned.
Only the FIR maker's occupation is
Oh,
mentioned.
right, absolutely. He was going to Purnima for his work. No. হ্যাঁ, সে তো সে মনিরুল যাচ্ছিল। আর মনিরুল হ্যাঁ, ডিসিতে কথা বলেনি। নো। এটা বলেছে যে এটা হচ্ছে রেজাউল যে আছে তার কথা বলেছে।
The complainant is the Rezaul.
Rezaul. He stated about himself.
ইট ভাটার কাজে পুণ্যিয়া রওনা দেয়।
কোথায়? Then income will be higher. If he was a mason, so automatically it will go. No, আমার কাছে no, I will stick to my case only. I will stick to my case only. As it has been deposed by the mother of the deceased in the court, Lordship.
So the court has come to the conclusion of this notional income.
Lordship.
Yes, recorded order. Yes.
By taking the awarded amount to the, before the, from the trial judge,
Yes.
they are not putting any objection. They are
No,
not.
no,
they are
no,
not satisfied with, awarded
No,
amount.
I'm not satisfied. No, it is written. Yes, we are satisfied.
Yes, recorded order. Learned advocates for the parties are present. Our learned advocates, hearing is concluded. Let this matter appear on 23/12/2025. For judgment.
Grateful, Lordship. Where the card?
$94.
94.
Not this week.
Lordship, I am appearing on your. Lordship, on the sales of judgment, Lordship, whoever.
Who is for the appellant? The insurance company.
Lordship. Lordship.
Okay, not today.
Lordship. My submission is, Lordship.
No, let the other side appear. Tomorrow I'll take it up.
No, Lordship, my submission is something different, Lordship.
Yes,
On the same judgment, Lordship, two
Yes.
appeals have been filed, Lordship.
yes.
One from the side of the insurance company.
So let both the appeals appear.
Lordship, that's the
Give the
submission.
number, both will appear.
52/2025.
Let this matter appear with FMA,
FMAT MV
FMAT MB
52/25.
52/25.
Lordship, kindly keep it tomorrow, Lordship.
Tomorrow. Yes. You are the appellant.
No, Lordship. No.
Without. Yes. Okay, this is with regard to the recovery matter. I have passed an order, I can grant. But statutory to. If there is stake, now the matter is ready for hearing. So you, the vehicle owner is not appearing. You are for this, that is the claimant. I shall consider. Because even if you give them opportunity of hearing, who knows whether they will appear or not. Right? Anyway, I shall consider the Madhya Pradesh judgment and what I have delivered, and I shall pass the necessary order. Because you see, what happens, you see, a businessman engaging 3-4 drivers, you see, it is not possible to go and verify their driving license. Okay. Yes, if you are driving your own vehicle and you have not renewed your license, then to some extent vehicle owner can be responsible. But so engaging the driver, yes, if the insurance company thinks fit that yes, I should proceed, insurance company will proceed. If the insurance company thinks fit that we will condone, insurance company can condone. Yes. Yes. So that is not true. Anyway, whatever it is, what evidence you have adduced, all these things are to be considered from the facts of the case. Otherwise, you see, if it is a vehicle owner's own fault, definitely vehicle owner is liable. But it is not possible to keep track upon all drivers and this thing, how many, whether you have renewed your vehicle or not. For example, if you have a personal driver, at best once in a year you will ask him or twice that whether he has renewed the license or not. Not that every time you will go and ask him. So these are the two real problems. But henceforth, insurance company, if wants to proceed, they will proceed. And I have also delivered another judgment that with regard to the vehicles who have not renewed their insurance, in spite of reminder notice by the insurance company has to report it to the transport authority against these vehicle owners. Because you see, vehicles are flying on the road without their insurance being renewed. So if after reminders they don't renew, immediately inform the transport authorities for steps. In another judgment, I have observed that. No. Final judgment. Yes. So because the awarded sum they have not yet withdrawn because there is a stay. And you see, you have not challenged the quantum also. Yes, that has to be definitely that has to be awarded. That. Yes, awarded sum along with interest, the claimants will be entitled to withdraw. Awarded sum, yes, awarded sum if the appeal fails, even if the appeal succeeds also, they will be entitled to withdraw, you will be permitted to recover. So they will be entitled to withdraw the awarded sum along with interest deposited, and 25,000 has to be returned to you. Yes, after compliance of the due process. Yes, record an order. Learned advocates for the parties are present, heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 23rd, 2025. Yes. Yes. So you have given that your own calculation? If we give your own calculation, then you are appearing in that matter. Whatever it is, you tell her and give your own calculation. I have to, otherwise I have to consult that Motor Vehicles Act itself. Yes. ফাইল করলে ওই রেকর্ডটার সময় তাটা পাঠিয়ে দেবে। Yes. Now next week.